My name's Amanda White. I'm the Operations Director here with Marine Renewables Canada. And I want to thank you all for attending this webinar. And I want to thank Aaron and Felisa as well for participating in this webinar, especially to Felisa for providing for expertise on the Jones Act. And I know many of us know what the Jones Act is, but we don't really know what is involved in the Jones Act. So Felisa is one of those folks that does. So I'm sure we'll learn a lot. A few quick things I'll say. For those of you that maybe aren't members of ours, I wanted to give you a bit of background of MRC and offshore wind. So Marine Renewables Canada, we brought offshore wind into our mandate back in 2018. And since then, we've been focusing on the developing industry in the US and opportunities that are or possibly can be available for Canadian companies. And we've been working, doing various activities. Sorry, guys, I turned my phone off. Various activities over the years towards that. We commissioned a study back in 2019 on what opportunities exist for Canadian companies in that industry. We also led a mission to the US Offshore Wind Conference in Boston in 2019. I think many of us, the last time we really did anything was probably in 2019, because we haven't been able to do much since then. But we've been working on developing a US offshore wind market intelligence bulletin. So this project is something we've been wanting to do, and it's basically we're working to provide a market intelligence bulletin to our members and our industry that will encompass all of the information regarding the US offshore wind industry in one easy spot. Because as we know, there is so much information out there for the various states, the various regions, the various projects, and it's changing constantly. And one of the things we've heard that it's difficult to keep up to speed on what's going on. So we're hoping that this bulletin that we are creating is going to assist with that. Initially, we're going to send it out once a month. If it's possible, we'd like to do it more frequently, but to start, it will be monthly. And the first one is scheduled to come out in September. So stay tuned for that. We are also working on this offshore wind webinar series, which we are doing in conjunction with the Government of Canada and with the Trade Commissioner Service at the Consulate General of Canada in Boston. So this is the first of that series. We have another one coming up in July, which I'll mention at the end of this webinar, and then you'll see a few more after that as well. We also have a few other activities that we're in the midst of planning over the next 6 to 8 months, so just stay tuned because we'll be doing some announcements on that as well. So to get things going, I want to welcome Erin Donahue. She is the Trade Commissioner covering Defense and Ocean Technologies at the Consulate General of Canada in Boston. Erin's going to say a few words and then introduce our presenter for today.
Thanks, Amanda. My thanks to Marine Renewables Canada for hosting the session. We greatly appreciate it. Just a bit of background on me, as Amanda mentioned, I'm the Trade Commissioner responsible for Ocean Technologies at the Canadian Consulate in Boston. Our office is part of the Canadian Trade Commissioner Service, which, for those of you who don't know, is located in embassies and consulates throughout the world. We assist Canadian companies by providing market intelligence, problem solving, and introductions to local contacts in a variety of industries across New England. I've been following developments in the offshore wind industry probably as long as I've been at the consulate, but it's only been in the recent past few years that the offshore wind industry in the US Northeast has really begun to accelerate, with now over 16 active leases ranging up and down the coast from Massachusetts to Virginia. By 2030, estimates suggest that this offshore wind industry in the US could create a $70 billion pipeline. I know many Canadian companies are actively exploring opportunities in the supply chain. And in speaking with clients, questions around the Jones Act, how it applies to the US offshore wind industry, and how it applies specifically to your business often come up. So we thought it would be good to bring in an expert. The team at Foley Lardner have been great partners to the Canadian Consulate in Boston, providing information on a variety of different legal topics relevant to Canadian clients entering the US market. I greatly appreciate Felisa taking the time today to join us and to provide a bit of an overview of the US Jones Act and how it applies to the US offshore wind industry. Going forward, please do not hesitate to reach out to me directly if you have any questions or if you're looking for additional information. As Amanda mentioned, we hope that this is the first of a series of webinars. Also hoping that as things in the border continue to open up, we can have some more information on actual in-person activities you can start taking part in within the next few months. So with that, I would like to introduce Felisa Sanchez. Felisa has a transactional practice involving a wide variety of corporate, finance, and commercial matters for domestic and international clients in the financial services, maritime, transportation, and energy sectors. Felisa has almost 20 years of experience representing public and private companies in complex transactions. With that, I'll turn it over to Felisa.
Thanks, Erin. Let me go ahead and get my screen up. Get that shared.
While you're doing that, Felisa, I will just add one thing in that I forgot to mention. So we will allow for some questions at the end of this presentation. We should have time, but in the meantime, what you can do is just type your questions in the chat function or the Q&A function, and I will pose those questions once we're done. If you do want to ask them yourselves, I do believe have the ability to unmute anybody. So if you want to stick your hand up, if you do want to ask a question, and I will unmute you so you can ask it verbally if you prefer that way. Otherwise, just put it in the chat function and we will get to it.
Thanks, Amanda. Actually had just made a note to include that as well. So thank you. Good afternoon, and thank you for joining us today. I'm very happy to be here. I first heard of the Jones Act about 20 years ago when I was a summer intern at my law firm, and I was asked to research the Jones Act as it applied to offshore oil and gas construction activities. And my mentor had been involved in this area for years. I remember thinking it was a very obscure area of law. Some of it just didn't make sense. But I never at that time would have imagined that 20 years later, we're looking at applying the Jones Act to a new and exciting industry developing on the offshore US. As many of you know, the Biden administration has focused heavily on transitioning, the energy transition from oil and gas activities to clean energy development. Earlier this year, the administration set a really lofty goal to deploy at least 30 gigawatts of offshore wind in the US by 2030. For comparison's sake, I believe Europe last year, which was really the leader in offshore wind, had approximately 25 gigawatts. The US had 27 megawatts, so 0.027 gigawatts. The lofty goal is going to be accomplished by a very heavy administrative focus on promoting new lease sales, opening up new areas, completing review of construction and operation plans quickly and efficiently. The goal is to ultimately unlock a pathway to 110 gigawatts of offshore power by 2050. Obviously, that contemplates a large scale and very, very rapid development of offshore wind in the US. Over the next decade, this will present opportunities not only for US industries, but as mentioned previously, also to foreign companies in Canada that have the expertise and service providers that can assist with the development of these projects. Let's take a look at a couple of maps that I think help understand the US offshore wind capacity, just as some baseline information. This is the offshore wind speed map at 90 meters. Some of you may have seen this before. It clearly shows that a large portion of the US coastline along both our East Coast, our Pacific Coast, our Gulf Coast, and the Great Lakes Coast are ripe for offshore wind development. You will also see here a map that shows the depth of the seabed off the US coastline. This is relevant because you're going to be looking at potentially different technologies depending on the depth. You'll see on our Pacific coast that there is a very rapid drop off to deep waters. Along our Gulf Coast and the majority of the East Coast, you will see shallower waters offshore. And then along the Great Lakes and our northeastern coast, you see pretty deep water fairly quickly, not quite to the level of the Pacific drop off. But this is relevant because anytime you're looking at over 60 meters of depth, you may be looking at a transition from the monopile foundation wind structure to a floating structure. And that would create slightly different opportunities. A lot of the approach on the Jones Act and other regulations can be very similar, but it may open different opportunities up depending on your industry. So generally what we're going to talk about today, what's the Jones Act, what types of activities are restricted by it. We're going to take a closer look at the implications for the Jones Act to offshore wind projects in various phases. We'll look at site selection phase, research and development of the site. We'll also look at the construction and installation, which is where a lot of focus has primarily been centered during these conversations, and then also the ongoing operation and maintenance phase, which will continue for many years in the future. I will also, as part of the looking at the implications to offshore wind, I'd like to try to walk through one of the recent customs rulings and how it applied the Jones Act to an actual proposed project offshore. Then we'll conclude with a brief overview of potential strategies that may or may not be relevant to your industry, but that are helpful in understanding some options you may have when it comes to complying with the Jones Act. So what is the Jones Act? It is a body of laws which limit the following activities. It's transportation of merchandise between U.S. points, U.S. coastwise points, actually, transportation of passengers between U.S. coastwise points, towing, and dredging. You'll hear me use the term coastwise. In addition to Jones Act, that's just a different name for the same body of law. The coastwise trade is the transportation of merchandise or passengers between U.S. coastwise points. And let's take a look at what that means. So a coastwise qualified vessel, these are the vessels that are going to be permitted to be engaged in U.S. coastwise trade. They have to have a U.S. flag. They have to be owned by U.S. citizen owners, and it's not a simple test. It's actually a very complex test that requires at least 75% ownership at every tier of the ownership structure up to the top. You cannot have a foreign entity in that ownership structure for that 75%. You also are going to have U.S. citizen requirements for chief executive officers, percentages of your board of directors or similar managing bodies are going to have to be U.S. citizens. So it's a pretty strict test. In addition, that vessel has to meet U.S. build content requirements. And I know this is an area that a lot of foreign manufacturers pay a significant amount of attention to. In order to meet a U.S. build requirement, all the major components of the hull and the superstructure must be fabricated within the U.S. There's a wide variety of rulings and litigation as to what constitutes hull and superstructure, what is a component. That's probably beyond the scope of today's discussion, but that is something that is looked at closely. The vessel must be assembled in the U.S. and any components that are not structural parts of the hull or the superstructure can be fabricated in a foreign shipyard or abroad and then installed, but they will look closely at that component and to determine whether or not it's a major component or not. Also, a vessel that is rebuilt outside of the US will lose its Jones Act eligibility if a major component of the hull or superstructure is substantially altered or replaced. So what is a coastwise point? Coastwise point is going to be any point within the territorial waters of the US. So when looking at the shoreline of the US, it will be generally 3 miles offshore. It also includes all inland waterways, rivers. This includes the Great Lakes. It will also, a coastwise point will also be considered a point on the US outer continental shelf where you have installations or devices that have been attached to the seabed. But those installations or devices only become coastwise points if they are for the purpose of exploring, developing, or producing natural resources. Now, very recently, it has been clarified legislatively that this includes offshore wind. Prior to the past year, there was some question. I think people generally thought it was, but that has been clarified. And any foundation, a wind turbine, a vessel anchored on the OCS is going to become a coastwise point. You will see that there has been some clarification recently that a pristine seabed is not a coastwise point. So when you have a site that is being researched, when you have a site that does not have an installation in place yet, it is not considered a coastwise point, and you'll see why that's important here in a little bit. So let's look at the first, I guess, type of activity that's restricted by coastwise trade, and that is the transportation of merchandise. This is where you see most of the violations. It's either this or passengers, but the transportation of merchandise is restricted for a vessel, a foreign flag vessel, cannot provide any part of the transportation of merchandise between points in the US to which the coastwise laws apply. So in breaking that down some, let's start by looking at merchandise. What is merchandise? Merchandise is very broad. It has been determined to be valueless material. So trash on a New York barge has been determined to be merchandise, rocks, materials from the seabed, de minimis materials can now be merchandise. The largest exception to what constitutes merchandise is vessel equipment. And this very recently has been clarified to mean an item necessary and appropriate for the navigation, operation, or maintenance of a vessel, or for the comfort and safety of the persons on board. So what that means is a foreign flag vessel can transport vessel equipment between US coastwise points and not violate the Jones Act. This is an area that has been subject to a lot of development over the years. In the early 70s, it was expanded from a pretty narrow definition to any equipment that was necessary for the mission of the vessel. That was expanded over the years until I think 2008 or 2009. It actually was interpreted by the Customs Bureau to mean a large multi-million-dollar subsea structure that was going to be installed. And that raised a lot of challenges. For the past decade, there have been multiple challenges raised by US ship owners and a battle between foreign flag owners and US flag vessel owners as to what is the appropriate definition for vessel equipment. This most recent clarification came out in 2019 by the Customs Bureau. It is, I guess, broader than I think a lot of the US shipping industries feel it should have been, but it is not as broad as has been in the last 20 years. So it is a scaled back version of what you have seen previously. The next question you want to look at when you're trying to determine whether or not the transportation of an item between is going to violate the Jones Act is there a movement between two U.S. coastwise points? And if you recall, just a few minutes ago, we talked about what is a coastwise point. So a port is a U.S. coastwise point because it's within the U.S. territorial waters. A installation on the OCS is a coastwise point. So for instance, the wind turbine foundation. If you have transportation of an item from the port to that site, it is a movement between two U.S. coastwise points. However, if the OCS site has not yet been developed and is a pristine seabed, you don't have a second point. So there is no movement between coastwise points, and it is not considered a Jones Act violation to transport an item on a foreign flag vessel between those points. The other, I guess, item that frequently comes up here when you're looking at between two U.S. coastwise points, and it's a strategy that's frequently used, is to have merchandise that is transported from a foreign port to a U.S. coastwise point. So for instance, from a Canadian port to a wind turbine site, if there is no offloading of that material before the installation site, that is not a violation of the Jones Act. So that is a Jones Act compliance strategy. If you look at what is transportation, this is a little bit nuanced when you look at the customs regulations. They have developed an exception over the years that pipeline and cable laying are not transportation. And the rationale for that is that the cable or the pipes are not transported, they are being paid out from a vessel. So if you have a cable reel that is laying the cable as the vessel moves, that is not transportation because it's being paid out rather than unloaded. It seems a little technical, but that is a very long-standing position of the Customs Bureau. The very recent development relates to lifting operations. And prior to 2019, the rule for lifting operations offshore was very strict. And it had raised significant safety concerns for offshore lift and transfers between vessels. And I guess maybe a visual, I don't know if yes, you can see this. So if a vessel was, this is the prior rule, if a vessel was rotated about a central axis, so around the center, that was a permissible movement during lifting operations. But if during a lifting operation, the vessel rotated around either one of the terminal points, that was a violation. Any lateral movement side to side was considered a violation of the coastwise trade rules. And that caused a lot of concern due to potential safety in the operations. So in 2019, when Customs clarified the vessel equipment standard, they also clarified that lifting operations, that any movement that was a result of lifting operations that was subordinate to or a direct consequence of that lifting operation was not considered transportation. So that is a fairly recent development. Moving on to the next area, and this is probably the second largest area where you see potential violations, but I think is relevant to probably a broader number of industries, is the transportation of passengers. So the Jones Act prohibits non-coastwise qualified vessels from transporting passengers between ports or places in the United States to which the coastwise trade laws apply. The biggest point for interpretation is, what is a passenger? What is a crew? Crew is the exception to what is considered a passenger. And the test for that is that person or that individual directly and substantially connected with the operation, the navigation, the ownership, or the general business of the vessel. That is actually a fairly broad standard. So any crew members that are on board, for instance, an installation vessel that are being transported from a port to an offshore coastwise point, if while on board that vessel, they are involved in preparing for lifting operations, the navigation, the planned installation, that is contemplated generally as part of the crew of the vessel and would not be a violation of the passenger restrictions of the Jones Act. You also need to consider the movement between points. For the passenger restrictions, any movement within U.S. territorial waters of a passenger would need to be on a coastwise qualified vessel. Any movement within a harbor, and any movement between two U.S. points. Towing, I will not get into, I think, in as much depth, but there is a requirement that tugboats that are engaged in towing where U.S. coastwise laws apply be coastwise qualified vessels. This generally, in our example, you'll see how this may or may not come into effect, but it's most of the tugs involved usually are coastwise qualified. There is also a dredging restriction under the Jones Act. Only U.S. coastwise qualified vessels can engage in dredging in navigable waters of the U.S. However, dredging is a very specific definition. It is the mechanical excavation of the seabed and movement of the soil on the seabed. For instance, we mentioned earlier that cable laying was a permitted activity. Customs has also clarified that the jet propulsion movement of the seabed in order to trench or cover up a cable is not considered dredging because it is not a mechanical excavation. It is jet propulsion of the seabed rather than excavation. So let's talk about recent developments. As I mentioned, there's been quite a bit of back and forth over the years between foreign flag vessel owners and contractors and U.S. vessel owners. In 2019, Customs issued a clarification of its position on vessel equipment that we've discussed. It also set forth the guidelines on offshore lifting operations. As a consequence to that publication, some litigation that U.S. ship owners had filed against Customs, I think in 2017, was still outstanding, and they moved to amend that litigation to basically clarify this as an additional harm to their interests. And this litigation is ongoing. It's in DC. We do not know at this point how it will play out, but they are basically seeking a narrowing of the vessel equipment definition and more restrictive interpretation of lifting operations, removal of the cable laying and pipeline exceptions. But that is something to keep your eye on, but has been in the works for over 3 years with actually very little movement. Also, in the last 6 months, Customs has started to issue rulings. They had gone into a period where they were not issuing a lot of rulings. In that 2019 guidance, they very strongly recommended that anyone involved in an offshore project seek a Customs ruling to clarify whether or not that item was vessel equipment, whether or not the activities contemplated were coastwise trade violations or not. And they have actually started to publish, they've always published these, but they've started to become more active in receiving and publishing some offshore wind related rulings recently. And the scour material installation, scour material is the rocks that gets installed around the foundation of the wind turbine. There is a ruling, we'll actually walk through the different scenarios that were outlined in that ruling and how the Customs Bureau applied the Jones Act in that specific situation. There has also been a ruling on wind turbine generator installation and also offshore cable repair. And they have been fairly consistent in their application, as you'll see when we go through the scour material. Given the fact that everything seems to be recently accelerating, rulings are coming out more frequently, guidance has been published, this ongoing litigation, I think my biggest message for you is to stay alert of potential changes. There's going to be ongoing changes here on for the next several months as the administration works to establish a more solidified ground rule set for the players on offshore wind. Prepare for uncertainty. Consider Jones Act issues very early in the planning stages of a project. Typically, you're looking at determining whether or not certain activities are Jones Act violations or not years before they're actually carried out. And then I also strongly echo Customs rule recommendation that you apply for a ruling determination if there is any doubt. So let's switch to looking at some of the applications in the various phases of offshore wind development. First, we have the site selection phase. So here you're looking at a lot of research vessels, a lot of seafloor mapping, surveys for weather, for environmental, for marine mammals. You're going to look at AUVs and ROVs being involved. This one is probably actually the easiest to look at because there is a broad standing exception that oceanographic research is not considered coastwise trade. So the transportation of samples of research equipment is not considered merchandise and is not considered coastwise trade. But you do need to be careful to consider who qualifies as a passenger for a vessel. There is at least one ruling that's about 10 years old where it's very clear that the crew that went out to conduct the research, they were deemed to be crew members of the vessel because they were conducting the research from the vessel. They had left certain equipment on site to conduct the research. Several months later, a crew went out to retrieve that equipment, but was not necessarily related to the research of the vessel. They just went to go pick up the equipment. And those individuals were actually determined to be passengers because they were not engaged in oceanographic research. I think that is a situation, if you have a situation similar to that, that is an area you would clearly want to seek customs rulings and clarification on what would be a permissible activity for that equipment removal. So during the construction and installation phase, this is probably the phase that has the most variety of activities. You're going to be looking at the laying of cable and transmission lines from the shore out to the site. You'll be looking at foundation installation, the development of potential spars for offshore floating facilities. You'll be looking at supply boats, barges that are there for construction purposes. You'll be looking at the actual installation vessels, which I think is where a lot of the publication has been focused. What types of vessels are out there to assist with installation, since there are no current US flag installation vessels that are capable of installing offshore wind facilities. You're looking at diving vessels supporting the construction activities, tugs pulling the barges. You're looking at personnel transfer vessels who are carrying crew to and from offshore, heavy lift vessels. All of these, you need to break down the actual activity of what they're doing to a very minute detail and consider whether what they're transporting is merchandise or vessel equipment. Are they passengers or are they crew members? Are you transporting between two coastwise points? Is there an applicable exception? The determination during this process is going to be very fact specific. That is why we do recommend that if you look at a customs ruling, you will see that there's an inordinate amount of detail specified as to the exact activity that's being proposed. Down to sometimes you will get information on geographical actual coordinates as to where these operations are taking place, and that is a key factor. You'll want to consider permitted lifting operations if you're involved in transfers offshore. Again, generally speaking, there has been an exception that has been built in for lifting operations that are in the vicinity of an installation. However, I think the question will then become, what is within the vicinity? Immediately within the vicinity, half a mile. Obviously, there's going to be a gradation, and that's an instance where you'll want to get some clarity and determination as to what would be permitted by that lifting operation. One of the things to consider in the construction and installation phase in particular is if you have any foreign components that are being built and installed on a coastwise qualified vessel, that can violate the US build requirement. It can invalidate their coastwise registration. So if you are building a specialized piece of equipment that's going to be installed on a US coastwise qualified vessel, you need to take a close look at the specific requirements for build content and modifications to a vessel so that it does not lose its coastwise qualification. During the operation and maintenance phase, you're going to be looking at very similar activities to what you had in the construction phase. Personnel transfer vessels, cable repairs, and maintenance vessels are going to be conducting a lot of the same activities that the installation vessels carried out. And the interpretation of an application of the GENS Act is going to be very similar for those. So let's get down to the nitty-gritty. And this is where I think it's helpful to see how the Customs Bureau approaches questions of coastwise trade. So this is actually a scenario that was laid out by Great Lakes Dredge and Dock. They applied for a customs ruling to the Coast Guard, and they were looking to install scour material at the Martha Vineyard site. They outlined multiple scenarios, which I've summarized over the next few slides that we'll walk through, and asked the Coast Guard, the Customs Bureau to weigh in on whether or not that was a violation of coastwise trade. And the first scenario that they set out was they proposed loading the scour materials, so rocks, aboard a foreign flag vessel at a US port. That foreign flag vessel was then going to transport the rocks to the site for installation. It would unload the material to the seabed prior to the installation of the foundation. It would then proceed to the next site and do the same. and it would continue to do so until it ran out of material, at which point it returned to the US port, reload, and resume. So the Coast Guard or the Customs Bureaus clarified that this is not a violation of coastwise trade. And the reason it is permissible is you don't have a second coastwise point. So you're transporting between the US port, which is a coastwise point, and the pristine seabed at the proposed site. So when you have a pristine seabed, that again is currently considered not a coastwise point. So that is not a transportation between two coastwise points and is a permissible activity for a foreign flag vessel to engage in. Scenario B that they set out was basically phase 2 of the project. So they would load a second round of material at a US port, use that same foreign flag vessel to carry it out to the site. But at this point, the monopile foundation has been installed. And so they would now be adding a second layer of protection material to that site. So the Customs Bureau clarified that this would constitute a violation of coastwise trade because it is a transportation of material that does constitute merchandise from one coastwise point to another coastwise point. Scenario C is the one I think that may be of most interest, I think, on this call, and it was the same process as scenarios A and B, except that instead of the scour material being loaded at a US port, it's now being loaded at a Canadian port. The foreign flag vessel will take the scour material from the Canadian port to the site, install, round 1 would be on a pristine seabed, round 2 would be at the site, and the vessel would have to return to Canada for each load of material once depleted between installations. So the Customs Bureau correctly held that this was not a violation of coastwise trade because you had transportation between a foreign point and a US coastwise point. So this is a permissible activity under the Jones Act for a foreign flag vessel. Scenario D, you have the scour material is loaded onto a foreign flag barge. So not the vessel we were talking about previously, but a foreign flag barge, which in Canada, and that barge is then transported either to US territorial waters or to the OCS. And it's anchored there for storage during the course of the process. The foreign flag vessel that we had talked about previously would now transport the material from that barge, either in US territorial waters or on the OCS, out to the site for round 1 for the pristine seabed, round 2 for the monopile foundation. The Coast Guard or the Customs Bureau indicated that it is the same analysis as scenario A and B because the barge, when it becomes connected to when it's located either within US territorial waters or when it becomes connected to the US, becomes a coastwise point. It is there for the purposes of developing offshore resources. So it is a coastwise point. So the transportation between that barge and the site, if it's a pristine seabed, is not coastwise trade. If it is the site with an installed foundation, it is a coastwise point, and that is considered a Jones Act violation. Scenario E. So now you have scour material loaded onto the foreign flag construction barge in the US. That barge is now towed to the OCS by a coastwise qualified tug. The material is installed directly from the construction barge to the site. This breaks down to 2 issues. One, the towing statute. Since the towing is being carried out by coastwise qualified tugs, that is a permissible tow. The question of whether or not merchandise is being transported is a second question that the Customs Bureau looks at. And again, you're looking at the same scenario we've looked at A, B previously, which is when it goes to a pristine seabed, It is not coastwise trade, so it is a permissible activity, but if you're transporting it to that coastwise point, it is a violation. So even if you have a permissible tug, there is a scenario where you have a potential violation of the Jones Act if you are installing at a installation site that's already built. And scenario F was basically same as scenario E, except they used foreign flag tugs. In that case, it was a violation of the towing statute, and they never even got to the merchandise question, so it was a prohibited activity under the Jones Act. So I think that sort of breakdown of how they approached simply the installation of scour material demonstrates that this can get very technical. It can get very, it's very, very fact dependent. The Customs Bureau is going to look very closely at exactly what is occurring, and their, some of the activities can be structured so they're permissible, some may not be able to be. So some of the strategies that are being discussed for Jones Act compliance are, probably the most common, the use of a coastwise qualified feeder vessel to accompany any foreign flag vessel. So this is obviously an expensive approach, but if there's no way to otherwise structure an operation so that it's Jones Act compliant, this is an option. You have the foreign flag vessel that is conducting whatever activities, be it construction of the actual wind turbines. And then you have a US coastwise qualified vessel that shadows along with it, that carries the merchandise, that carries any items that are not going to be vessel equipment. The other, I guess, widely used strategy is a joint venture with a US coastwise vessel owner. You've seen this a lot with some of the European companies starting to pair up with some of the US partners. This can be very effective if you can reach a joint venture with someone that is situated to complement your industry and your services provided. You can also consider a time charter of a US coastwise vessel. You cannot do a bareboat charter where you just take the vessel and go on site and do your own thing. The vessel still has to be controlled by US citizens, but it can be time chartered as long as the time charter is structured correctly. You can also, as we discussed in the examples, transport from a non-US site to the coastwise point. So if you have merchandise that can be transported through a Canadian port to the coastwise point, that is not going to be between coastwise points and is not going to require a Jones Act vessel. You're also, I don't think we talked about this earlier, but there is an exclusion where transportation of merchandise that is loaded at a point in the US, carried out, and then unloaded at the exact same point where it was loaded is not coastwise trade. And this obviously does not apply to a lot of situations, but there are a few instances where something that would constitute merchandise may be needed for offshore construction, and it can be loaded on the vessel at exact coordinates, carried out to the site. It cannot move from the vessel, but it can be utilized at the vessel, and then it would be transported back and unloaded at the exact same point, and that would not be a violation of coastwise trade laws. And then the other question is, the broad sort of what we've been talking about generally is, does an exception apply? Is it vessel equipment? Are your individuals transporting on the vessels really passengers, or are they crew? Is there a cable laying exception? So there are things to consider when you're structuring your project. Again, this is something you want to look at very early on, brainstorm, involve, consult with counsel, consult with the Customs Bureau on a customs ruling, If the plan changes, you can always update your customs ruling request and they will provide you updated guidance. So that is, I think that is one of the big takeaways that we've had since the last, I guess, year, is the Bureau is really looking to clarify these situations on a fact-dependent scenario. So they want to do it on an individual case basis rather than set general guidelines for the most part.
Felisa, if I could just interrupt you for a quick sec, just because the question we had was about what you were just talking about.
Okay, and actually I'm moving to questions, so perfect timing.
We had a question that said, what do you mean by the exact same point? Is it a port, a dock?
It can be the port, so the exact same point on the port. It can be the exact same point in territorial waters. So for instance, recently there was a customs rule, and I can't remember what the subject matter was, but they provided the exact GPS coordinates within the territorial waters where they were going to be loading the merchandise onto a foreign flag vessel. It was going to go offshore, and then it was going to come back and unload that at that exact same GPS coordinate. And there was a marking of the GPS coordinates that was taken, and the vessel then returned to that exact point by GPS coordinate to unload. So that can be within the territorial waters. It can be the installation site that's a coastwise point on the OCS. It can be the exact point in a port or harbor, but it does need to be the exact same point. And you can get customs clarification with a ruling to sort of insulate you from potential enforcement action on that.
Great, thank you. There was another question, someone asking if you could review scenario E just quickly again.
Sure, let me. That one?
Yes.
Yeah, so in this scenario, the material, there's basically two vessels involved here. So there's a foreign flag barge and a coastwise qualified tug. And so the material is loaded on the foreign flag barge within the US. It's then towed to the OCS by the coastwise qualified tug, and the material is then installed directly from the barge to the site. So that again breaks down to two analyses that are occurring. The first question is the towing statute. So the towing restrictions under the Jones Act, since these tows are being carried out by coastwise qualified tugs, that is a permissible activity because the statute prohibits foreign flag tugs from engaging in towing within US waters. So the US qualified tug brings that activity within compliance of the Jones Act. The second portion that you're looking at is, do you have a transportation of the merchandise on the foreign flag barge from a coastwise point to a coastwise point? And so that part of the analysis is similar to what we set out in scenario A and B, where the US port is point 1, and then either the seabed, the pristine seabed is point 2. In that analysis, you do not have a violation of the coastwise trade for transportation of merchandise because you don't have it between US points. You have it between a US point and a pristine seabed. If you look at that same scenario where you're transport for the second round of scour protection, where they're installing it on the previously installed foundation, now you have the coastwise point established on the OCS. So now the movement of that merchandise on the foreign flag barge from the US port to the OCS point is a violation of coastwise trade if carried out by the foreign flag barge. Does that answer the question that was raised?
Yeah, I think so. I actually have a bunch more questions here for you, so we're going to try to get through a few of them. It's probably going to jump around a little bit.
That's fine.
So one of the first ones that came in is, will the waiver agreed by Alaska to the Passenger Service Act regarding cruise ships not having to call at a West Coast Canadian port be used as precedents for offshore wind?
If it does, it's going to have to come through a legislative act. It is possible, I suppose, but I would honestly doubt that would be used as precedent. The other part of the Biden administration's focus, not just on clean energy, but also on supporting U.S. workers, they are looking to try to keep the Jones Act intact and to support U.S. shipping industry as much as they can. So just my personal viewpoint is I don't think that would be considered precedent. But again, you see all sorts of crazy legislation proposed every year when it comes to the Jones Act, so you never know.
Okay, thanks. All right, some of these are going to get pretty specific.
Okay.
For a site survey being conducted on a non-coastwise vessel or a foreign flagged vessel, we may be collecting core samples and then offloading them in a U.S. port for laboratory analysis at a U.S. lab. We understand that this is not a contravention of the Jones Act. Are we correct?
Yes. So when we looked at the site survey portion, that would be what's considered oceanographic research. So sampling of core materials from the seabed, water samples, any of that is taken is considered research materials and not merchandise. And so that can be transported back to a U.S. port.
Okay, great. Do the U.S. authorities differentiate between cable laying and cable repair?
They will look closely at what is being involved in cable repair. So there is a ruling from, I guess, 2 or 3 months ago that looked at cable repair for one of the offshore wind facilities where a cable had become unearthed and they were having to relay part of that. And basically all the activities proposed were permitted. But key in that was as part of that repair, they were paying out the cable, they were laying it out. So if you're going in and just perhaps looking at small portions, I mean, that's something that I guess it really depends on what type of repair you're looking at, but generally speaking, that's probably going to be a permissible activity. You just probably would want to outline exactly what you're proposing for the Customs Bureau, set it out in a ruling, and get that pre-approved.
Okay, great. I think this is a quick one. Is the Jones Act interpreted differently between individual states, or is it the same for everybody?
It's the same for everybody. I will say that, I did want to mention this earlier, but generally it's the Customs Bureau that is charged with enforcement of the Jones Act. That said, the Customs Bureau is not offshore patrolling for violations of the Jones Act. Typically what happens is these are where you have potential violations. It's because you have competitors who are closely monitoring compliance by foreign flag vessels and will issue reports to the Customs Bureau that may or may not be investigated depending on whether or not the Customs Bureau feels that was a violation.
Okay.
Quickly, I mean, I know we have a bunch of questions, but this might be relevant for a bunch of people. Felisa, who can apply for customs rulings? Does it have to be the vessel operators? Can it be others that, for example, you mentioned if equipment's installed on a vessel, it might affect the whether or not it's considered to be U.S. flagged. Can the equipment installation folks apply for that ruling? Does it have to be the vessel owners and operators?
It does not generally does not have to be the vessel owner. I would have that discussion with the vessel owner and determine who is the best person to make that application. Generally, your vessel owner is probably going to want to do that to protect their coastwise qualification. So.
Okay. Okay, I know we are very close to time here. I'll see if I can get a few more quick questions in. We have actually a lot of them sitting in there. Are Aboriginal individuals or groups residing in Canada considered U.S. citizens or the equivalent under the Jones Act?
No, no. So I don't believe so. It's a very strict U.S. If they have a U.S. citizenship as an individual, and it has to be actual U.S. citizenship, that is what qualifies as an individual U.S. citizen.
Yeah. Okay.
But typically, when you're looking at the citizenship requirement, you're actually looking at entities and entity structures that are owning the vessels.
Yeah. Okay. There is a quick question here. Is the installation, if the installation is beyond the 3-mile limit, does the Jones Act provisions apply?
I'm sorry, you broke up the last part. Jones Act
provisions apply if it's beyond the 3-mile limit?
Yes. So again, that is where you're looking at. So it applies at all points within the 3-mile limit and the inland waterways. Beyond the 3-mile limit, it only applies if you have an established coastwise point. And that is, as we discussed, the installation or attachment to the seabed on the OCS, specifically for the purposes of developing and exploring natural resources, which does include wind.
Okay, one more quick one, and I know there's a ton in there, guys, and I'll see if we can get to them maybe after the webinar too, but I know you mentioned ROVs and AUVs at one point. So what about ROV support? Does the ROV company and vessel have to be US flagged to service the US wind field or wind development?
Generally speaking, not. You have to look at the activities that are going to be conducted from those vessels. Generally, if it is just deployment of the ROV for purposes of conducting research or assisting with installation, it's going to fall, the ROV or the AOV is going to be considered vessel equipment. And as long as you're not transporting merchandise that is being transported from a US site to the offshore site, and it's a transportation between coastwise points, simply the use of the ROV and the AUV are not going to be violations.
Okay. If you have,
again, and I do want to qualify that, again, this is all highly fact specific. So if you have any unusual facts, you probably really want to take a close look at it.
Yeah, no, absolutely. Okay, I'll see if I can get one more in here. Would a US-Canadian joint venture partnership have to be a minimum 75% owned by the US partner to be compliant with the Jones Act?
So if that joint venture will be owning a vessel that's going to be engaged in coastwise activities, yes. Typically what you'll see is the joint venture either structured so that the US entity has 75% ownership. There are other strategies that have developed where the foreign partner may have only 25% equity, but there's permitted uses of warrants and debt that can equalize the investment in the project for the JV partners. But again, that is all very nuanced and fact specific. The other thing that you see frequently is a joint venture where the vessels are still owned separately by the US coastwise qualified entity, and then will be chartered to the joint venture. Okay.
And one more quick one, and then we'll call it there, because otherwise I think we could probably go on for a while.
Perhaps we should have cut this a little shorter and had more questions, so apologies for that.
Okay. Can a foreign or Canadian crew join a Canadian cable lay vessel while the vessel is located in US waters?
So a Canadian crew, I'll outline the facts that I'm assuming here. The Canadian crew would, I assume, board the vessel either at a US port or somewhere within US waters, and then be part of the crew as it and conducts its cable laying operations. And they then become part of the crew.
Okay. So they can join, they're able to join the vessel while the vessel is sitting in US waters.
Yes,
Okay.
yes.
Okay.
That doesn't differentiate the determination of whether or not they're passengers, whether it's a crew member or not.
Okay. I think that is it. We are over time. So I want to thank you very much, Felisa, for doing that. It's certainly increased my understanding of the Jones Act. And like I say, I'm sure we could talk about this for days.
We get into all sorts of detail.
And there's going to be a lot of questions. I will remind everyone that we have Erin here, Erin Donahue, who's fabulous and has been really a great assistance to us in our work towards looking at opportunities in the offshore, U.S. offshore wind industry for our members. So folks, don't hesitate to reach out to Erin if you need help, if you want connections to folks that can help you with these things. She's there and she's a wealth of knowledge, so certainly reach out to her. And I know we didn't get to everybody today with your questions. Certainly send them off to me maybe after the webinar, and I'll see what we can do. But we will be making these slides available. Felisa, I think you're going to send me them in a PDF format so I can get them out.
Yes, I will.
So we'll send those out to you as well. I do want to thank everybody for attending. And again, thank you, Felisa, for doing this. Thank you, Erin. I don't know, Erin, if you had any closing remarks before we sign off.
No.
You good? Okay.
Thank you so much, Felisa. This is great. I've learned a lot too, and this is why we bring in experts like yourself to answer questions.
Yeah. Sounds good.
No, thank you
everybody.
very much, everybody. Have a great day.
Thank you all.
Okay, bye.